Good day, everyone. My name is Marjorie Joy L. Amar, and I will be talking about founder shares, redeemable shares, trust fund doctrine, treasury shares, and watered stocks. So, what is a founder share? According to Section 7 of the Revised Corporation Code of the Philippines, founder shares may be given certain rights and privileges not enjoyed by the owners of other stocks, where the exclusive right to vote and be voted for in the election of directors is granted. It must be for a limited period not to exceed 5 years from the date of incorporation, provided that such exclusive right shall not be allowed if its exercise will violate Commonwealth Act Number 108, otherwise known as Anti-Dummy Law, Republic Act Number 7042, otherwise known as the Foreign Investment Act of 1997, and other pertinent laws. So we can say that founder share is a special kind of share because only the founders or the promoters can have these shares. So from the name of this type of share, founder, binibigay lang to dun sa mga nagpasimula or yun nga, yung mga yung promoter ng corporation. Sila yung mga conceptualize, nag-organize to the formation of the corporation. So, parang reward na to sa kanila. Meron silang certain rights and privileges na bukod tanging sila lang yung makakaranas out of all the other types of shares. So, isa na nga sa mga privileges na yon is to vote and be voted as director. Di ba usually para maging isa kang or maging part ka ng board of directors, kailangan malaki yung share na meron ka or malaki yung hawak mo na share. Pero kung founder ka ng corporation, pwede kang maging director kahit pa maliit na, maliit or hindi mo na-reach yung dapat na number of share para maging director ka or maboto ka as a director. Pero may exception dyan. Ito yung right to vote and be voted can only be enjoyed by a founder for a minimum or a maximum of 5 years from the date of incorporation. Also, hindi rin niya ma-execute or ma-exercise yung right to vote and be voted as a director kung mababiolate ng founder yung Anti-Dummy Law, Foreign Investment Act, and other pertinent laws. So yung anti-dummy law, it is a law created to penalize those who violate foreign equity restrictions and evade nationalization laws of the Philippines. It prohibits dummy or proxy arrangements to accomplish transactions not allowed under Philippine law. So it prohibits dummy or proxy arrangements. Example, may foreigner and hindi siya Filipino citizen. Tapos gusto niyang bumili ng property sa Pilipinas. Hindi yun allowed under the Philippine law. Kapag hindi ka Filipino citizen, mahirap kung bibili ka ng property sa Pilipinas. So, yung ginagawa ng iba, gumagamit sila ng middleman or third person. Yung dami nga na Filipino citizen na siyang mag-a-act as if siya yung bibili at magmamay-ari afterwards ng property. So kung ganun yung violation, ganun yung situation, na-violate niya yung anti-dummy law. Next, Foreign Investment Act. It is the policy of the state to attract, promote, and welcome productive investments from foreign individuals, partnerships, corporations, and governments. So, dito may freedom yung mga foreigners to invest in different corporations, partnership, government, and such. Pero, syempre may restriction. Under Foreign Investment Act, papayagan lang na mag-invest ang isang corporation, ang isang investor sa isang corporation when the corporation has significantly expanded livelihood and employment for Filipinos, promote welfare for Filipino consumers, and other factors in which magbe-benefit ang Pilipinas at ang mga Filipino. Also, under Section 8 of RA number 7042 or yung Foreign Investment Act, it provides foreign investment negative list. Ito yung list of investment areas reserved to Filipino nationals or Filipino citizens only. Meaning may restrictions din and may mga areas lang na allowed ang mga foreign investors to invest. Now, going back to founder shares, bago magamit ng mga founders yung stock options nila sa isang corporation, may certain date na kailangan nilang hintayin muna bago nga magamit or magamit yung stock option nila. So, may tinatawag na vesting schedule. Ito yung time or the exact date where shareholders are allowed to exercise their stock option. So, sa vesting schedule, monthly or quarterly yung installment or yung pag-vest ng share according sa agreement nila. So, dito sa vesting schedule, nag-generate yung stock monthly or quarterly according to their agreement. So, pero kahit na ganon na nag-generate siya monthly or quarterly, hindi pa pwedeng galawin ng founder or gamitin yung share na nag-generate until fully vested na or tapos na yung vesting process. Dito rin, merong option na 4 years with a 12-month cliff. Meaning, wala munang vesting or wala munang madadagdag na share for 12 months. Tapos, after the first 12 month, after a year, dun pa lang magsisimula yung vesting process. Or for example, ito, sabihin natin na ang isang founder is supposed to receive 100,000 share. So, kung i-apply natin tong 4 years with a 12-month cliff, so sa first year, zero pa yung share or wala pa siyang matatanggap na share, wala pang nag-vest na share. On the second year, dun pa lang magsisimula yung pag-vesting. Pag-vest ng share, sabi natin, equal installments. So, for the first year, 25,000 shares. Second year, 25,000 shares. For the third year, another 25,000 share para maging 50,000 share na yung meron ang isang founder for 3 years. And then, fourth year, another 25,000 shares, 75,000 share na siya. And then, after another year, another 25,000 share, hanggang sa maabot niya na yung supposedly na ma-receive niyang share, which is 100,000 share. Kapag ka naabot niya na yung date na to, ibig sabihin, tapos na yung vesting schedule. Ibig sabihin, fully vested na yung share and pwede nang ma-exercise or magamit ng founder yung stock option niya sa corporation. Pero meron din naman iba pang options na walang cliff or wala na yung 12-month na wala munang vesting. Depende yun sa agreement kung paano yung magiging schedule of the vesting ng share. So bakit ba meron pa nitong vesting schedule? Kung pwede namang ibigay na lang agad, bigyan na lang agad ng compensation or reward yung mga founders. So, stock vesting provisions for founders is often demanded to gauge the commitment of people involved in the company and to protect equity from departing partners. So, it protects the corporation from free riders na after incorporation, for example, aalis na lang bigla or hihingi ng share, magdedemand ng share, Tapos, iiwan na yung corporation. So, with vesting schedule, kung ano yung deserve nila, yung time na nagstay at naghintay sila for their stock to be vested, yun lang yung share na matatanggap nila. Kung babalikan natin, for example, umalis sa year 3 yung founder, yung na-vest lang niya is 50,000 shares. So, ayun lang yung ibibigay sa founder. And then, the company has the right to buy back the uninvested shares at the lower cost or the then fair value, market value of the stock. Next, redeemable shares. According to Section 8, redeemable shares may be issued by the corporation when expressly provided in the Articles of Incorporation. They are shares which may be purchased by the corporation from the holders of such shares upon the expiration of a fixed period, regardless of the existence of unrestricted retained earnings in the books of the corporation, and upon such other terms and conditions stated in the Articles of Incorporation and the certificate of stock representing the shares, subject to rules and regulations issued by the Commission. So, yung redeemable share, tinatawag din itong callable shares. Ito yung mga shares na after a certain date binabawi or nire-redeem ng corporation yung share from the shareholder. Pero sabi nga sa Section 8, redeemable share may be issued when expressly provided in the Articles of Incorporation. So, if wala, then they cannot redeem a share. Hindi din pwedeng bawiin yung share or i-buyback yung share hanggat hindi pa dumadating yung napagkasundo ang date of redemption. At kapag dumating na yung date of redemption, obligated yung shareholder to sell the stock to the corporation. Sabi dito, regardless, yung naka-underline na words, regardless of the existence of unrestricted retained earnings in the book of corporation. So, kahit na wala silang retained earnings, pwede pa rin ma-redeem ng corporation yung shares. Kahit wala silang surplus profit, pwede na lang ma-redeem yung share. But take note that such redemption, dapat hindi siya magkokos ng corporate insolvency. It is required that the corporation should have sufficient asset in its book to cover debts and other liabilities. Therefore, redemption may not be made if corporation is insolvent or such redemption will cause corporate insolvency. Next, mandatorily redeemable share is it is a type of redeemable share that can be redeemed with cash or property, usually issued by employers to employees as part of their compensation package and to entice new employees. Yun nga, kahit na binigay na siya as part of compensation and to attract new employees. Since redeemable share siya, required yung employee na ipa-redeem yung share at a certain date or kapag ka umalis na siya sa corporation with cash or property. So next, trust fund doctrine. The capital stock, properties, and other assets of a corporation is a trust fund for the payment of the debts of the corporation. Creditors have the right to look up to satisfy their credits, and the corporation may not dissipate. So, ayun nga. Sinasabi lang dito na yung assets ng corporation is a trust fund na gagamitin para bayarin yung debt ng corporation. And pwede daw i-check yon na or makita ng mga creditors yung trust fund. So bakit? Para ma-check nila and to ensure that there is no distribution of assets hanggat hindi sila nababayaran. And any disposition of is fraud on the creditors of the corporation who extend credit on good faith of its outstanding capital stock is therefore void. So kung dinispose or dinistribute yung mga assets na laman ng trust fund sa mga shareholders na kahit hindi pa nila nababayaran yung mga outstanding debts nila, pwede silang kasuhan ng mga creditors. Next, treasury shares. These are shares of stock which have been issued and fully paid for but subsequently reacquired by the issuing corporation through purchase, redemption, donation, or some other lawful means. Such shares may again be disposed of for a reasonable price fixed by the Board of Directors according yan sa Section 9 ng Revised Corporation Code. So, ito naman yung mga shares daw na na-issue na sa shareholder tapos na-reacquire ulit ng corporation for the purpose na ibebenta rin nila afterwards with reasonable price na fixed by the Board of Directors. And ayun nga, it can be reacquired by means of purchase, redemption, donation, and through other lawful means. Pero, pwede lang ma-acquire yung share with surplus profits. Ayun yung pagkakaiba niya sa redeemable share. Itong, sabi kasi natin kanina, yung redeemable share, kahit na sa redeemable share, regardless of the existence of unrestricted earnings, kahit na wala silang surplus profit kapag pinag-uusapan natin yung redeemable share, pwede silang mag-redeem ng share basta hindi yon magkakos ng insolvency. Dito naman sa treasury share, kailangan meron silang surplus earning. Kapag wala silang surplus, then hindi nila pwedeng i-reacquire yung share na na-issue nila sa shareholder. Okay? So, kapag na-acquire na nila ulit yung share, tinatawag na yon na treasury share. At hindi na yon ibinabalik at kinaklasify as outstanding share. Hindi naman to retired share na meaning canceled na or wala nang value yung share. Pero hindi na siya nire-revert as an issued share kasi nga yung purpose ng pag-reacquire ng share is to reissue or to resell the share. Also, it is not part of the earned or surplus profits. So it is not distributable as dividend by means of cash or stock. But if there are retained earnings from the business of corporation, yung treasury share, being the property of the corporation, may be distributed as property dividend. So, what are stocks? Stocks that are issued at a price that greatly exceeds its true value, a scheme to defraud investors by offering shares at deceptively high prices. So, parang panloloko yung nangyayari dito. Nagiging watered yung stocks. Yung share, yung issued share, sinasabi na fully paid na, but it was much less than the par or issued value of the share. So, example kung paano nagiging watered yung stock is, sabi nga dito, a stock is said to be watered when its true value is less than its book value. So, nangyayari dito, kiniklaim or pinapalabas ng corporation na yung par value ng isang share is higher than its true value. Napalabas nila na mataas yung value ng stock kahit na mababa na talaga yung value nun. Ganun yung mangyayari. Ganun nagiging watered yung stock. So, um, when corporations issue shares at less than its par or issued value, meaning that the corporation has no enough asset or yung asset ng corporation is lower than the one declared to the public. So kaya nga may par value or nag-i-issue ng par value yung mga corporation sa stock nila is to let the public know and to make them feel assured na that the company or the corporation has sufficient asset para mapalagay din sila na may enough asset yung corporation bago sila mag-invest. But yung ginagawa ng ibang corporation to make it look like they have capital or enough asset, they issue shares stating as fully paid. But the truth is, mas mababa na talaga yung price ng stock kesa dun sa kinlaim nila na uh, price ng stock. So nasabi nila na ganito yung price ng stock na yun, pero ganito lang pala talaga kababa yung presyo nun. So ganun nang nagiging watered yung yung, yung stock. So sabi nga dito, it is a scheme to defraud investors. So yung mga directors and officers who consented to the issuance of watered stocks are solidarily liable with the holder of such stock in the corporation. So, ayun lang. Thank you!